Truth Espresso, episode 297.
Face it, we all would rather sleep in this morning. That's why God gave us espresso, to kickstart our zombified corpses into hyperdrive. And now, giving your mind and soul the morning shot of truth it craves. This is Truth Espresso with Daniel Minnick.
Well, hey there, this is your host for Truth Espresso, Daniel Minnick. Welcome all friends, family, foes, and lurkers alike to another episode of Truth Espresso. And of course, after the biggest news of the century that happened this last week, I felt compelled to throw my 2 cents in and to study and address the recent New York trial of former President Donald J. Trump and the verdict that found him guilty of 34 felony charges. So on May 1st, 2024, this day marked the first time in American history that a former president was tried for felonies and convicted. So this is the first time that we even brought a former president into court for felony charges. And then, of course, also history in the making. This is the first time that a former president has been charged with criminal misconduct, a felony, 34 felonies, such that now the media can refer to a former president, not just a former president, but a former president who served out one term and is now running for a second term as president, a convicted felon. And of course, we're going to see a lot of that in the mainstream media. Some people you refer to as Mr. or Mrs., if it's a man or a woman, or Ms. And some people, if they've earned a doctorate degree, in some contexts you might refer to that person as Dr. so-and-so. And of course, when someone is currently serving a term as president, you refer to him as President so-and-so. And then once that person is out of office, you refer to him as former president. And so that's kind of like a title for the person's name. But now, because of this particular verdict from a New York trial in Manhattan, former President Donald Trump is now going to have a new prefix for his name. The mainstream media is destined to refer to him constantly, probably in every media article and in every media video story covering him. They're going to refer to him at least once, if not multiple times, as convicted felon Donald Trump. They want to make sure that you, the viewer, the listener, get it deep down in your skull that you should think of Donald Trump as convicted felon, to make sure that it affects the way you think about him. And so we as Americans, and indeed the entire world, are now left speechless thinking about what the future holds, wondering what precedent this sets, disagreeing on whether this trial was even necessary or whether the verdict itself was actually an application of blind justice. For someone like former President Donald Trump, how could you have an actual fair trial when everyone knows who you are and everyone has an opinion of you? And when it comes to a place like Manhattan, New York, where about 95% of the voters vote for the other side, how is it even possible to get an impartial jury? But nevertheless, we are left with the outcome of this trial, and the whole world is trying to figure out what happens now. So what was this trial about? And as I was preparing notes for this episode and quickly realized there's just no way I'm going to figure out all the things that I want to say about it and all the details that I would like to cover about this case in one episode, I realized in looking at this that I was drinking from a fire hose. And so this is going to be part one, covering the Manhattan Madness, the New York Trump trial. So what exactly was the verdict in this? And then we're going to look at the background of what led up to the trial. So this case is about the fact that Manhattan District Attorney Alvin Bragg indicted Donald Trump on 34 felony counts of falsifying business records in the first degree. So that's the statement that was in the indictment. So falsifying business records, what exactly is that and what does that entail? Now, falsifying business records itself in the state of New York, in New York statute, is a second-degree offense. So there's falsifying business records first degree and falsifying business records second degree. Now, falsifying business records by itself qualifies as second degree. Falsifying business records in the first degree only happens if the falsifying business records are done with the intent to defraud or to conceal another crime. So, falsifying business records in the second degree, which merely means falsifying business records in and of itself, that under New York statute is a misdemeanor. But as we see, the falsifying business records, the 34 charges promoted were felony charges. So they're felony charges for falsifying business records in the first degree, and those charges happen only when, according to the statute, it is with, quote, intent to defraud, includes an intent to commit another crime or to aid or conceal the commission thereof, unquote. So, if the reason for falsifying business records has some kind of intent or notorious purpose to conceal another crime, then it becomes a felony. Then it becomes falsifying business records in the first degree. Well, if these charges that were brought against former President Donald Trump are felony charges, then what was this another crime? Well, as we will see when we study this case, it was all about conspiracy to undermine the integrity of the 2016 election. We know that there are a lot of people in high places who still cannot get over the fact that Donald Trump won that election. They are still bitter about it. They still consider that he somehow stole the election. You have the whole Russian collusion hoax and, where Trump is always referring to Russia, Russia, Russia. But of course, there's more than one way to skin a cat, as they say. And of course, there's more than one reason someone can concoct as to why Donald Trump should not be considered a legitimate president for his first term, and therefore deny him the possibility of getting a second term as president. And there are lots of people who believe that somehow, if Trump just simply ran a normal campaign for president, if he didn't push the right buttons and pull the right levers, he just had to have done something egregious to be able to win that election. There's just no way that he could have actually won it if he didn't do something wrong. And I mean wrong in a relative sense compared to like everyone else who runs for president. And of course, the idea is that somehow Donald Trump conspired to undermine the integrity of the 2016 election. So let's look at the background to the trial here. And the background, the things that led up to the charges, weren't from yesterday. They were from quite a few years ago. So the details of this particular trial begin in July 2006 when Trump met Stephanie Clifford, who's also known in her professional career as Stormy Daniels, and she is a porn star actress known for having relations with many, many people in high places. And Trump had met this Stormy Daniels at a celebrity golf tournament. And during this time, Trump was still producing the popular reality show called The Apprentice. And many people in the public know Donald Trump first from his part in the show The Apprentice. Now, allegedly, Trump and Daniels had relations at his penthouse there after they met, and they discussed about having her appear on the show The Apprentice. Now, I would like to say that as a devout Christian, I will suggest that if this affair actually happened, it's sinful and wrong on the part of both of them. Now, we do have to recognize sins and crimes, vices and crimes. It's still not necessarily illegal for this to have happened. It could be a civil issue. Of course, it's deeply immoral if it did indeed happen, but it's still not necessarily illegal. Unless his wife at the time, and still now, Melania Trump, decided to press for divorce, then it would come up as an issue there. I want to make sure that we all understand that if this did happen, I'm not in any way defending Trump as innocent in that regard. It may be immoral, but as far as the legal system that we have, especially when we talk about consistently applied law when it comes to elections and campaigns and such, this is kind of small potatoes here. So then, in 2011, Trump thought about running for president. He was exploring the possibility, and usually you do an exploratory committee, and then eventually you announce your intent to run and so on. But Trump thought about running, but he didn't actually run. But while he was exploring this, Stormy Daniels wanted to sell the story of her encounter with Trump to Life and Style magazine. Now, Trump's lawyer at the time, Michael Cohen, asked Trump if he wanted him to take care of this situation. And Cohen threatened the magazine with a lawsuit if it published the story. Now, of course, once again, if this testimony is true, it is also sinful and wrong to the extent Trump and Cohen were involved. If they're trying to cover up something that's immoral, then that action also would be immoral. And it's sinful and wrong to the extent that Trump would have been involved in this. We know what Cohen's actions were, but we don't know for certain how much Trump himself was involved in what Cohen did and was involved in the cover-up actions. Nevertheless, we also once again have to realize that lots of people or lots of organizations want some information not to go out. And of course, that can be unethical. But when it comes to a mutual agreement such that someone decides not to publish something and another one, they agree on it mutually, lawsuits can be threatened, however unethical, and there can be an agreement and stuff. It's dirty business here. It's dirty law if things like this happen, but it's technically not illegal. Now, we get to 2016. As Trump was running for president, Stormy Daniels' agent, Gina Rodriguez, wanted to publish the story of their alleged affair in the National Enquirer, which, of course, if we know anything about the National Enquirer, that's the perfect place for stories like that. And Trump's lawyer, Michael Cohen, helped suppress the story by paying Stormy Daniels $130,000 to sign a non-disclosure agreement with him. So this particular transaction, this particular agreement was between Stormy Daniels and Michael Cohen. And people craft and sign and enter non-disclosure agreements all the time for various reasons. So Cohen and Daniels entering into a non-disclosure agreement such that Cohen would pay Daniels $130,000 in exchange for Daniels agreeing not to publish the story in the National Enquirer is what gave rise to what we call the hush money allegation.
Andrew Rappaport's Rap Report is a podcast providing biblical interpretations and applications. It is a ministry of Striving for Eternity and part of the Christian podcast community. We provide a biblical view of cultural events, discuss how to apply God's Word to the Christian life, address issues that concern the church, and we even take some time to offer a correct understanding of those commonly misinterpreted passages of Scripture. You will hear from great guests like Justin Peters, Todd Friel, J. Warren Wallace, and Gabe Hughes. Andrew has the Rap Report Daily, which is a 2-minute Monday through Friday podcast, and then the longer Rap Report podcast for more content. Subscribe to both today by searching for Rap Report on any podcast app, spelled R-A-P-P Report, or click the podcast link at strivingforeternity.org.
Now, Michael Cohen was responsible for the payment. It was from his coffers, basically. He was doing the job of trying to keep this incident from going public. We need to think about this. There's the innocent until proven guilty aspect. We don't know how much of what Stormy Daniels, a professional actress, porn star, person who's had relations with, I think it was several thousand people over time, we have to wonder just how much she would embellish things if she did publish a story. So regardless of what happened, the story she would seek to publish, if she indeed intended to tarnish Trump's reputation during the 2016 election, may or may not have been entirely factual. I'm just trying to bring up there, just because she would have published a story about it does not necessarily mean that every detail was guaranteed to be completely true. The hush money arrangement, technically speaking, may not have just been, oh, we don't want you to let out these nuggets of truth. It could have also been, we don't want you to mix truth with lies here. And then we have to go through the whole thing of trying to figure out just how much is true and how much is false. That kind of blackmail and bribery, that kind of thing will happen. And so just because Trump's lawyer paid Stormy Daniels' so-called hush money not to publish something doesn't mean it was only about trying to prevent her from saying true things that he didn't want published. It could have also been that they didn't want her talking about this and adding details, so to speak. So whatever the case here, Cohen was responsible for making the payment to Daniels, and he kept delaying it, and presumptively he was having a hard time coming up with the money for a while, so he had to keep telling it's coming and delaying it. And then later on in the year, he used a home equity line of credit to pay for the agreement. And then Trump, the next year, in 2017, would later pay Cohen for the legal expenses. So the payments that Trump gave to Cohen were marked as legal expenses to reimburse him for the payments that Cohen made to Stormy Daniels, totaling $130,000 for not to publish the story about her relation with Trump back in 2016. So according to the business records that we see from April to December of 2017, Trump gave periodic checks to Cohen for these legal expenses. The total was $420,000 that Trump paid Cohen. So Trump paid Cohen $180,000 to cover the non-disclosure agreement and $50,000 for Cohen to make efforts to boost his poll ratings. Again, of course, that's just kind of paying for campaign help and stuff. It's not necessarily illegal. Now, Trump doubled the $180,000, which covers the legal expenses and the poll boosting stuff to $360,000 to cover any taxes that Cohen would pay on that income. And then Trump also added another $60,000. So he's going above and beyond in his reimbursement payments to his lawyer, Michael Cohen, to cover whatever taxes Cohen might pay on his income for the services he provided, and just giving extra money, like whatever you might need for this and whatever other things. So on Trump's side, he's paying Cohen for legal expenses to reimburse him for payments that Cohen had to make directly for Daniels and other things. And so then there's the question of, well, how much did Trump know? Was Cohen being a helper for Trump, kind of doing things behind his back? Maybe he told Trump, this thing will be bad for your campaign if it gets published. Do you want me to take care of it? And, maybe Trump was not involved directly in how Cohen handled things, and he's basically saying, well, you're my lawyer, you do what you think is right here, and then I'll reimburse you for whatever expenses you have to cover up front. So there's always these kinds of questions. How much collusion is there between a client and an attorney there? So I did say that all these payments that Trump made to his lawyer, Michael Cohen, were in 2017. So these payments were obviously after the election. Any money that Trump paid out of his account could not have been campaign financing directly, because his payments were done after he was elected president. All these payments were after the election on Trump's side. Now, if Trump were complicit in any crime that had to do with a federal election, under state laws, of course, since this is New York state law we're talking about, there would have to be proof beyond a reasonable doubt that Trump knew everything Cohen was doing and worked with him with full intent. It's possible, as I said before, that Cohen acted alone, or he was doing whatever he figured would help Trump, and then Trump would just cover the expenses and so on. There would have to be proof beyond a reasonable doubt that Trump knew what Cohen was doing and worked with him with full intent. It's possible that Cohen acted alone, doing unorthodox deals, and merely gave Trump the bill for legal expenses. That is a technical possibility, and that's what you have to prove didn't happen. A person isn't automatically responsible for what an attorney does on his behalf. If the attorney is acting alone, you have to prove a collusion there. So the crimes in the indictment that District Attorney Alvin Bragg brought in this trial were all about falsifying business records, which are normally misdemeanors, as I said. There's the first degree and the second degree, and if it's just falsifying business records, it's a second degree, and this is the bookkeeping equivalent of a parking ticket, as I've heard some people say. But these falsifying business records charges were upgraded to felonies or first degree because they allegedly were done with intent to conceal another crime. So, when it comes to this case, we have to ask the question, just what was that other crime? Because that's what have to be proved in the trial. Now, having the kind of affair that Trump allegedly had with Daniels back in 2006 isn't technically illegal, as I said before. It's not a New York State felony. That couldn't, in and of itself, be the other crime that turns bookkeeping errors into felonies. Is a hush money payment the other crime? Well, hush money arrangements also aren't illegal and are common throughout history. Even Thomas Jefferson supposedly gave hush money payments, not about illicit affairs and stuff, but for political reasons. So hush money payments are kind of common throughout history, especially in politics and among the rich and ritzy. Not saying that it's all ethical, not saying that it's squeaky clean, of course, but it happens a lot, and in and of itself, it's technically not illegal. A non-disclosure agreement happens a lot in business contracts, and Cohen and Stormy Daniels entered a non-disclosure agreement. Some non-disclosure agreements, like if you have a certain type of skilled job, for instance, I am a software developer, and if some places that I would work at, they might, in the work contract, possibly have me enter a non-disclosure agreement that I would not reveal business secrets if I were to leave that job and work at another company and reveal trade secrets and stuff. And so non-disclosure agreements are pretty common in certain professions. A non-disclosure agreement for one person to pay another person money in exchange for them not doing something that could be unethical, but it is not on its face a crime, much less a felony. So what is the other crime for which Trump was accused? Was it because the alleged intention of the payments to Stormy Daniels were to help his public persona during the 2016 election? Perhaps. We're kind of getting closer, if you play the game where you're trying to find something hidden and your only clue is the person who hid the item saying you're colder or warmer. I'd say that here we're getting warmer. But merely trying to help your persona in a campaign also isn't technically illegal or a felony. Anyone who's running for public office wants to have the best reputation in the public. And just because there might be something that could tarnish that person's reputation, and it's just an unethical but not illegal type of thing, and they enter a legal contract just not to publish a story about it, that doesn't necessarily mean that the person committed a felony.
I speak to parents all the time who come up to me and they see what's happening, but they don't know what to do. And I just want to stand up and say, you can do this. Here is a solution.
This is Yvette Hampton, host of the Schoolhouse Rocked podcast. Join us each week for a new episode as we offer encouragement and resources on biblical discipleship from popular speakers and authors, as well as parents just like you and me. Find out more at schoolhouserocked.com or listen anywhere you find your favorite podcast.
Merely wanting to try to avoid bad press without threatening someone with violence or stuff like that, but merely paying someone not to publish something, that might be unethical, but it's not necessarily a crime in and of itself, and not necessarily a felony. Of course, Michael Cohen, Trump's lawyer, was helping Trump out a lot and was gunning for a position in Trump's administration if Trump were to get elected. Of course, that's not illegal either. Cohen wanted Trump to give him a prestigious position in his administration, although he himself admitted that he didn't feel qualified. Now, he wanted that as some form of payment for his help with Trump's campaign. But Trump offered him a position, but it wasn't what Cohen really wanted. Cohen wanted something more prestigious. And they kind of ended up having somewhat of a falling out eventually. And in 2018, the payments were in 2017. In 2018, Cohen was arrested and charged with campaign finance violations because of the payments he made with Stormy Daniels. And he was also charged with tax fraud for not reporting about $4 million in income to the IRS for a taxi medallion business that he operated. Cohen was in trouble with the law, and part of that, not all of it, but part of it had to do with his particular campaign agreements with Stormy Daniels. Now, his payments to her was during the campaign. Trump's payments to him was afterwards. And so if Trump did something that was in violation of campaign finance laws, wouldn't it have had to have been done before the election was determined? That all depended on if what Cohen did was actually illegal, and then you have to prove how much Trump was involved with Cohen, or did Cohen kind of take matters into his own hands to help out Trump? Now, Cohen's original charges carried a maximum of 65 years in prison. And of course, if that were a possibility, that probably ultimately led Cohen to agree to a guilty plea and a plea deal. So Cohen ultimately pleaded guilty, and his sentence ended up being 3 years in prison. And in his guilty plea, he said that he committed the campaign finance violations, quote, in coordination and at the direction of a candidate for federal office, unquote. So back in 2018, when Cohen was charged and convicted and entered the plea deal, he basically threw Trump under the bus. And I'm sure that there was some kind of pressure for him to do that to reduce his possible sentence. And nevertheless, even the 3 years that Cohen spent in prison, it did not help his strained relationship with Trump. Trump's former lawyer seemed to turn into a bitter enemy. Because as we have seen in Trump's trial, Cohen openly admitted that he wanted to see Trump thrown into prison. So Cohen was not exactly an unbiased witness here, speaking merely to matters of law or events that transpired. Now, what about campaign finance violations? Because, is this an unusual thing either? It doesn't seem to be unusual. Bob Dole was charged and he ended up paying fines. The Obama campaign in 2008 had to pay a $375,000 fine to the FEC for campaign reporting violations. So if the issue had to do with records for finances that had to do with campaign violations, why wasn't the Trump campaign simply fined? Or why couldn't the FEC approach Trump, and even if it was later, and just fine him for these violations, just like they do every other campaign that ends up falling afoul these campaign reporting finance laws? Why wasn't the Trump campaign simply fined? Why did it have to turn into some kind of big show trial? Well, I think we all know the answer to that because there's a lot of opinion about Trump. He's someone that often either you love him or you despise him, and there are plenty of people in high places who despise Trump. So what's interesting about this whole trial and the charges here, the theory of the case, the DOJ itself, the Department of Justice, didn't really see a crime that was chargeable, and thus they didn't really pursue it. And as it pertained to these particular falsifying business records, at the time, as we're talking about 2023, by this time, it should have been too late to bring this case, because the time to charge for falsifying business records, as they were back in 2017, had passed. It had to have been by 2019. But we've also heard talk about how the statute on limitations of a misdemeanor was 2 years. So why did District Attorney Alvin Bragg see it necessary, according to blind justice, if that were the case, to press charges in 2023 on President Donald Trump? Why didn't they do this earlier when there was no question about statute of limitations? Why now? Why in 2023 when it was obvious that Trump was running for president a second time? Why did it have to be then and not earlier? Why now if it didn't have a political purpose? And of course, that brings us to where we will actually get into the trial, and that brings us to the end of this episode. So I hope that you enjoyed this episode of Truth Espresso, and I'm sure that we all know something about this particular trial. It's been in the news a lot, but I hope that some of the details and some of the questions might be some new information there. And as we'll get into the next episode, or part 2 of Manhattan Madness, the New York Trump trial. And so stay tuned for that, and God bless.
Thank you for waking up with Truth Espresso. Good morning, and God bless your day.
Hey friends, Daniel Minnick here again. If you liked waking up to this episode of Truth Espresso, I would really appreciate it if you would rate it on Apple Podcasts, Stitcher, or whatever application you use to listen to Truth Espresso.